Good morning to those of you in Canada, and good afternoon to those of you in Europe. Thank you for joining our webinar today on intellectual property rights in Canada. This is a webinar geared towards EU businesses, EU exporters to Canada, and anyone who would like to expand to Canada from Europe on a business angle. So before we begin, I would like to introduce you to our program, who is gladly hosting this webinar, the CETA Market Access Program for EU businesses. What we do is we help European businesses, particularly SMEs, take full advantage of the CETA trade agreement between Canada and the European Union. We help them gain comprehensive sector-specific information about the new opportunities CETA brings in terms of removing market access barriers, whatever they may be, with Canada. And we also provide guidance on how businesses can benefit from CETA while addressing challenges in their business strategies in Canada. And finally, for the sake of expansion to Canada, for the sake of creating a community among European professionals, we create sustainable channels of communication between EU businesses seeking to enter Canada and other institutional stakeholders. This project is entirely funded and supported by the European Commission and the European Union delegation to Canada. Our presenter today on intellectual property rights in Canada and under CETA is Georgina Starkman-Danzig. Georgina is a seasoned litigator, Canadian litigator, active before the Superior Court and Federal Courts of Canada. Commercial litigation is the foundation of her expertise, and she is best known for advocacy in intellectual property regulation, protection, and more specifically, anti-counterfeiting enforcement for goods. She's recognized as a thought leader in anti-counterfeiting legislation, policy, and practice. Georgina was actually selected in 2020 by the World Trademark Review 1000 ranking in their highest gold band category for Canadian anti-counterfeiting lawyers, and she was only one of 3 lawyers in Canada to have achieved this high tier gold ranking. So without further ado, I turn the presentation over to Georgina.
Thank you, Myrtle, for the introduction. And I want to begin by thanking the CETA Market Access Support Program and the EU delegation to Canada for inviting me to speak with you today. As you can see, we have a lot to cover in a relatively short time. My goal is to show you how CETA changed Canada's domestic IP policy and legislation, and to show you the positive impact those changes have had and continue to have on EU business exporting goods and services to Canada and/or setting up business in Canada. I will also be differentiating various types of IP or intellectual property and show you how and why even a moderate level of IP literacy benefits EU business. Thank you. Canada's IP landscape. If I could describe it over the last little while, I would say it has been percolating with change. And I believe that it shows that Canada is committed to a robust, transparent, and internationally consistent regime for IP rights. Well prior to CETA coming into force, which was in September of 2017, Canada was and remains a signatory to many international IP treaties, including but not limited to those that are on the slide. Canada's compliance with its international commitments, however, requires implementation of domestic legislation consistent with those international obligations. So by way of example, the major changes to Canada's copyright regime, the Copyright Modernization Act, which was proclaimed into force in 2012, were done in large part to align Canada's domestic law with 2 WIPO treaties that it had been a party to, the Internet Treaties. And Canada's changes to its domestic laws on counterfeiting, found in the Combating Counterfeit Products Act, could arguably be said to have been made in anticipation of its upcoming commitments to CETA and other international obligations. So fast forward to 2017, when CETA was implemented. To give effect to Canada's CETA commitments, Canada signed on to 5 more international IP treaties listed on the screen, which in turn necessitated major changes to Canada's corresponding domestic legislation. Continuing with Canada's commitment to a robust intellectual property regime, 9 months after CETA was implemented, Canada announced, and it's the last bullet on the screen, Canada announced an investment of over 56 million euro or 85.3 million Canadian dollars in a 5-year comprehensive IP strategy to help business creators, entrepreneurs and inventors doing business and innovators doing business in Canada understand, protect and access intellectual property through a comprehensive IP strategy. So in my view, Canada's IP landscape shows it is committed to a robust, transparent, and internationally consistent regime for intellectual property rights. Next slide. So why should EU exporters care about Canada's IP laws? I've given some reasons on the screen. Thank you. IP rights are territorial, they're valuable, they need to be protected against infringement and theft, and CETA incentivizes EU exporters to consider Canada as a great market choice. And in my view, each of those elements are the reasons why EU exporters should care about Canada's IP law. I mean, and if we drill down a little bit further, intellectual property is one of the most important and valuable assets your business may have. And the degree to which a business can effectively identify, value, and commercialize its IP is material to its success. But intellectual property rights, like other property, are jurisdictionally specific. For example, if you own a trademark for a particular good or service in one country, it does not necessarily mean you own it elsewhere. So securing your IP rights in your export or foreign market like Canada and understanding the risks associated with the use of your intellectual property in that foreign or export market prior to entry is critical. Each country has its own domestic intellectual property laws. Even when you use an international application system like Madrid for trademarks or the Hague system for registration of industrial design applications, your international application will be evaluated by the laws of each country for which you are seeking registration, based on that country's domestic IP landscape. The same principle applies for enforcing your rights. Procedures and remedies may differ country to country. So CETA has incentivized EU exporters to pursue their scientific, artistic, and business endeavors in Canada by ensuring that the intellectual property that they own can be used with confidence and adequately protected in Canada. That's why knowing what these rights cover and determining under what circumstances these rights can be protected and what you can do if they've been infringed before an EU business enters the Canadian market is critically important. Next slide. In 2019, the Canadian government published an annual report called IP Canada Report 2019, which provided statistics and trends on the use of intellectual property in Canada. Research presented in that report explored the relationship of intellectual property awareness and holdings on the business activities of small and medium enterprises. The report concluded that SMEs that have a higher awareness of IP, along with those that hold formal IP, are much more likely to experience higher growth, expand their markets, and receive various types of financing. In addition, as the chart shows, the report found that SMEs holding formal intellectual property are 4.3 times more likely to have expanded internationally and 5.4 times more likely to plan to expand internationally. So with these figures in mind, CETA is perfectly positioned to assist EU SMEs expanding internationally or seeking to expand internationally. And as I will show as the presentation goes on, CETA's intellectual property provisions provide those SMEs with confidence that when they do expand into the Canadian market, they can be assured that their IP rights will be adequately protected and enforced so as to maximize their monetization of those rights. Next slide. CETA and the intellectual property rights regime. So CETA, the Comprehensive Economic and Trade Agreement between Canada and the EU, came into force on September 21st, 2017, and immediately eliminated 98% of the tariffs. On the third anniversary of CETA coming into force, so that's September 2019, the EU Commission reported that bilateral trade between EU 27 and Canada had increased by 24% for goods and 25% for services compared to trade pre-CETA. The EU Commission also reported that this increase is, quote, much better than similar trends between the EU and the rest of the world over the same period of time. On the IP front, CETA dedicated a full chapter to IP rights. Next slide. And the objective in CETA as it relates to IP is twofold: to facilitate the production and commercialization of innovative and created products and the provision of services between Canada and the EU, and to achieve an adequate and effective level of protection and enforcement of intellectual property. Next slide. Chapter 20 in CETA was divided into 5 sections. It had general provisions which set out the principles to be followed, standards which identified the various categories of IP rights, enforcement, the principles for domestic IP enforcement, border measures, and cooperation, which committed the parties to CETA to continue to cooperate on IP-related matters covered by CETA. So let's look at what intellectual property is. Intellectual property refers to creations of the mind, inventions, literary and artistic works, as well as symbols, names, and images used in commerce. Intellectual property relates to the form that an idea takes. Ownership of IP rights gives you certain rights and opportunities, but those rights may be different depending upon what type of intellectual property you may have. Next slide. There are many different types of intellectual property. Intellectual property is divided into 2 general categories: industrial property, which includes patents, trademarks, industrial design, and geographical indications, and copyright. It is important to know what kind of intellectual property you have so you know how best to protect, enforce, and commercialize it. So let's jump into the different types of IP rights. We'll start with the copyright. In the simplest terms, copyright consists of a bundle of rights that help protect creative works so long as they are either literary, musical, dramatic, or artistic in nature. One of the main rights provided through this bundle of exclusive rights is the ability to reproduce the work the copyright is meant to protect. However, that's not the only right provided through copyright. Other rights include the right to publish a work, translate it, or perform it, among others. Copyright also exists automatically when the original work is created. Formal registration is not required, but registration is recommended. Tips on copyright in Canada. The term of copyright protection is currently the life of the author plus 50 years. But I'd like to point out that that is changing to life of the author plus 70 years. The timing for that change is not yet known, but it's likely to take place within the next, it will take place within the next 2.5 years. Indicating copyright by a C and a circle, etc., is not required but helpful. You should know that there is a database of registered copyrights that is accessible for free and is managed by the Canadian Intellectual Property Office. Canada recognizes moral rights, neighboring rights, and provides for a fair dealing exemption. In terms of enforcement for infringement, there are broad rights to enforce, both civil, criminal, and as well, copyright is protected at the border using the intellectual property rights border enforcement regime. There are also broad remedies available for copyright infringement, which include an entitlement to obtain damages and profits, or statutory damages, or minimum compensatory damages, and there are a variety of other remedies that can be obtained, including declaratory remedies, injunctive remedies, etc. So it is a very well protected right. Next slide.
Georgina, just to interrupt, for some of those that are recently joining, I just want to remind you again that you can ask some questions if you would like on the questions tab on the side of your screen, on the right side of your screen, and they will be answered after the presentation. Thank you.
Thank you, Myrtle. Next screen. What I've provided for you here is just a quick comparison between the EU and Canada on the different copyright regimes, identifying some of the elements that were the minimum standards that CETA necessitated. A couple of interesting points in comparing the two regimes. First, online infringing acts. Canada's statutory notice and notice regime is markedly different from E-commerce Directive 2000, which requires as a condition for limited liability that the online hosts expeditiously remove or disable access to content they host when they are notified of the alleged illegality. In Canada, the statutory notice and notice regime does not require that the intermediary disable or remove access to the alleged infringing content. Rather, in Canada, copyright owners notify an intermediary or an ISP that it is hosting copyright infringing work, and the ISP is legislatively obligated to forward the notice electronically to the alleged infringer. Also, I'd like to point out under the protection of TPMs and RMIs, Canadian legislation, as required by CETA, prohibits the breaking of digital locks or technological protection measures and prohibits the removal or alteration of rights management information. And this conduct in Canada can be subject to civil sanction, but if it's done knowingly and for commercial purposes, it can also amount to an offense and be subject to criminal sanction by way of fine or imprisonment. Next slide. Let's look at trademarks now. Trademark is a shorthand linking your product and your service to you, and it helps consumers differentiate their products and services from those offered by others. So think of McDonald's Golden Arches, or the Nike swoosh, or Louis Vuitton's monogram canvas. Those are all trademarks. And trademarks can be a word, a sound, a design, or a combination of those. And Canada also recognizes non-traditional trademarks, which can be things like scent and color. Next slide. Some tips on trademarks in Canada. The benefit, of course, is that the trademark owner is provided a legal monopoly to use the trademark in association with the goods and services for which it is registered. The term of protection is 10 years, and that term is renewable. Indicating trademark with a TM or other marking is not required, but it's helpful. Again, Canada has a database that is accessible for free to find registered trademarks, and that is managed through the Canadian Intellectual Property Office. I'd like to point out that a trademark and a business name are not the same thing. Registering your business and its name in Canada is something that's done through provincial legislation. Registering your trademark is something that's done through federal legislation. Also, I'd like to point out that Canada protects trademarks, whether they are both registered and at common law or unregistered trademarks. Registration, however, gives exclusive right to the use of the trademark in association with the protected good and service throughout Canada, and an unregistered trademark or a common law trademark provides protection, but the protection is limited to the geographic area where the trademark owner can establish goodwill and reputation arising from use. Again, enforcement is robust. There is civil enforcement, there is criminal enforcement, and registered trademarks can also be protected using Canada's border enforcement regime. Next slide. The benefit to EU business upon the implementation of CETA essentially is focused on Canada signing on to the Singapore Treaty, the Madrid Protocol, and the Nice Agreement. And as a result of that, on the trademark front, post-CETA, Canada is now generally on par with the EU. And the Canadian Intellectual Property Office, because of Madrid, now accepts and examines applications filed by foreign Madrid Protocol applicants seeking Canadian registration, making it easier for EU business to apply for registration rights. Next slide. Geographical indication. So what is a GI? For my European colleagues on the call, you will have far more familiarity with GIs than perhaps Canadians. But a GI is a sign, symbol, or a word affiliated with a product that has a specific geographical origin and possesses specific qualities or reputation that are essentially attributable to that place of origin. The rights are collective rights owned by either a producer group or competent government body. So until CETA came into effect, GI protection in Canada was limited to wines and spirits. CETA significantly expanded Canada's GI protection to include 22 product classes or categories of applicable agricultural products and foodstuffs. And this expanded group of EU GIs is listed at Annex 20C to CETA. If you have a protected GI, the term of protection is unlimited. Next slide. So CETA had a significant impact on Canada's GI legislation. It expanded, as I said, the GI protection to new product classes or categories of applicable agricultural products and foodstuffs. And it necessitated that Canada implement an administrative regime to prevent the unauthorized use of protected GIs, enable the addition to the list of protected GIs, block registration by third parties of listed GIs, and now GIs are also mandatory to be protected under the border enforcement regime. Next slide. Patent. So what is a patent? A patent is a legal right granted by government to an invention that is novel, useful, and not obvious. And it in it can include improvements made to existing products and processes. Patent protection is limited again by the jurisdiction granting the patent, and the rights only arise upon the granting of the patent. Next slide. In Canada, a patent protection is 20 years from the date the patent application is filed. Again, the scope is territorial. There is a 12-month grace period in Canada. So after first disclosing the invention, you have 12 months to file your patent application without losing rights. A freedom to operate search when you have patents or a portfolio of patents is very important. It provides valuable information about whether your product infringes upon a third party's patent in the market you're seeking to enter. So it's something that I would recommend to foreign business looking to come into Canada to engage in a freedom to operate search. Again, a patent and a trade secret are fundamentally different in terms of how they can be protected. A patent is disclosed to the public fully, but provides the owner with a statutory monopoly and a right to protect against unauthorized manufacture, use, and sale, whereas a trade secret is proprietary information that is not disclosed to the public. It's never registered, and it retains its status as a secret as long as it remains a secret. Patents are not covered by Canada's IPR border enforcement regime, and also the protection is limited to civil remedies for infringement. There are no criminal sanctions for patent infringement. Next slide. Some of the changes that arose to the patent regime in Canada arising from CETA are on the screen, and include the 3 points on the screen as you can see them there. They impacted the term of protection for pharmaceutical patents. They provided a change to the rights of appeal, making them the same for innovators and generics. And they also solidified the minimum term of protection for data as being 8 years for protection of biologics and classical small molecule. Next slide. Industrial designs, also covered by CETA. So an industrial design is the original feature of shape, configuration, pattern, or ornamentation, or any combination of these, and the visual features of an article that distinguish it from its competitors. In order to have an industrial design, the design must be novel, and registration is required. So unlike copyright or trademark, registration of an industrial design is required. Next slide. So some tips on industrial designs in Canada. The term of protection is valid for up to 15 years from the date of filing. The scope of protection, again, is territorial. So a registered industrial design in Canada is valid in Canada, but not elsewhere. Same thing in Europe is valid in Europe, but not in Canada necessarily. A maintenance fee is required in order to maintain your registration. Marking of the industrial design, while it's not mandatory, it is highly recommended, because without it, there could be a detrimental impact on your ability to recover damages in the event of an infringement of your registered industrial design. Again, there is a database of registered industrial designs that is managed by the Canadian Intellectual Property Office, and that is easy for you to access. In terms of enforcement for infringement, you have civil rights of enforcement only, and it is not included in the border enforcement regime. Some of the benefits for industrial designs that were derived from CETA, essentially, CETA drove Canada to accede to the Hague Agreement and modernize its Industrial Design Act and regulations. As a result of that, EU business that choose to file an international industrial design application through the Hague may now include Canada in that application. As a result, only one set of fees in one currency is required to be paid through WIPO, and it provides for a simpler rights maintenance and management system. Border measures. So there were specific articles in CETA that addressed a variety of procedural and substantive enforcement thresholds. Some of the elements that were required to be included in the domestic legislation are set out on the screen. I'm going to take Canada complies with all of them. I'm going to just take you to the next slide and talk to you a little bit about Canada's border enforcement regime. First of all, it covers trademark registrations, copyrights, and geographical indications. Canada's IP border enforcement program has been in place since about 2015. IP rights holders can file a document called a request for assistance with customs in order to commence their participation in the program. Essentially, it's a recordation of their registered trademarks, copyrights, or geographical indications. Once the request for assistance is filed, it is valid for 2 years and renewable. There is no fee to you for filing your request for assistance. And once it is filed, then Customs is empowered, if they identify a suspect shipment, they are empowered to contact the contact identified on the form filed, the request for assistance, and detain suspected shipments of counterfeit products or pirated works or infringing geographical indicators pertaining to the reported rights. And so that detention can take place for up to 10 days. And in that 10-day period, Customs can reach out to the intellectual property rights owner, and the rights owner is given certain information to assess whether the shipment contains products that are counterfeit. If the IP rights owner identifies that the product being shipped contains counterfeit goods, pirated works, or infringing geographical indications, in order to detain the goods beyond the 10-day cycle, the rights holder can either commence an action before the federal courts or seek to settle with the importer of record. An interesting new development is that prior to July of 2020, in-transit goods were not included in the border enforcement mandate, but effective as of July 2020, in-transit goods are now covered as goods that can be detained by the Canadian customs regime should they contain suspect counterfeit goods, pirated works, or infringing geographical indicators. Next slide. So what this slide is, if you could advance the slide, Myrtle, is just a quick summary of the IP border enforcement regime, comparing some elements between the EU and Canada. One of the interesting line items, if I could point out, relates to simplified procedure. Canada does not have a simplified procedure for dealing with counterfeit goods. It currently does require either the commencement of a lawsuit to detain the goods beyond that initial 10-day period, or an agreement or a settlement that's entertained with with the importer of record to deal with the imported goods in a manner that is satisfactory to the rights holder. We also don't have a small consignment procedure, which I know that they have in some parts of the EU, but ultimately the system is working. I commend all of you who are importing or exporting goods from Canada to file a request for assistance and participate in the program because it has proved to be of benefit for those that are participating in the program. Next slide. The EU CETA has been successful for EU businesses who are looking to come to Canada. And what you have on the slide are two companies, European-based companies, who have acknowledged that they have benefited from CETA in terms of their management of their transition to conduct business in Canada. The first company, Arco Info, I'm just going to share with you a little bit about who they are. They are a digital solution software original equipment manufacturing company with some proprietary solutions, and they provide several access points for customer traction. Their platform, which is the back office slice in their tech stack, has been built up to digitally organize, manage, and archive information in digital format. So Arco Info is doing business in Canada, and you can see from the quote on the slide is that they have acknowledged the importance of the protection of their IP rights in Canada. And I can tell you that from my discussion with them, they did say something that I thought was very interesting. They said, and I quote, "One area that is critical in the process of expansion to a foreign market, whether another province or another country, is to understand whether you can play on the same field as the others that do what you do in your target market." For this, Arco Info says that CETA, they're thankful to the organizers of CETA for creating one of the most level playing fields for companies to play on, to play on going there or coming here. So I thought that that was very interesting, that their take on CETA, and I completely agree with it, is that it created a level playing field in terms of intellectual property rights between the EU and Canada. The second EU success story that I want to highlight for you is a company called Stainless Steel Pool and Spa, and I'll just read you briefly who they are. The firm Stainless Steel Pool and Spa, located in the famous ski town Whistler, BC, is an official Canadian partner of the company Berndorf Baderbo, the European leader in designing and manufacturing stainless steel swimming pools. Since its establishment in 1960 in Austria, Berndorf Baderbo has completed more than 8,000 aquatic projects worldwide, and entering the Canadian market was another milestone in its rich history. And Michael Roos, the owner of Stainless Steel Pool and Spa, has said of IP and CETA that IP is critical to our value proposition because it distinguishes the products and services his company provides from those of its competitors. These are two companies that have entered the Canadian market, each of whom have acknowledged the benefits that CETA has provided to them in the context of maintaining and enforcing their IP rights in Canada. Next slide. So I think what we can take away from this presentation, and I know that there was a lot of information, but some of the key takeaways that I want to share with you is that CETA has provided expanded protection for GIs for high quality, unique EU food and drink products in Canada. It's provided stronger IPR border measures for counterfeit goods, pirated works, and infringing GIs. It is now a participant in 5 international harmonized systems for the registration of trademarks, industrial designs, and patents, making registration more simplified for foreign registrants. And it has improved IP rights for innovative pharmaceuticals in Canada. Next slide. There are a number of resources that are very helpful that can be available to EU businesses looking to come to Canada. We've listed some of them on the slide. There is a paper that is going to be released shortly, a CETA-themed report on intellectual property rights, and that report will include even more references to resources that can help you in designing a strategy that can take you into Canada. One thing that goes without saying is it is important, in addition to having a level of IP literacy yourself, to also ensure that you are provided with the appropriate professionals in your target country that can assist you in navigating the domestic IP laws that you will need to navigate in order to effectively transition your business into Canada. So without further ado, that was a lot of material to cover in a short period of time, but I am available for any questions that you may have arising from the presentation.
Yes, Georgina, we do have a question here. Excellent information, thank you. Some companies may be hesitant to provide all the detailed documentation that patents require. Is there ever a time to not go for a patent, assuming all criterion could be met?
Yes, I mean, that's a great question. And that goes back to my comment about trade secrets and patents. So, you know, the most famous, if you think about a trade secret, to some degree, it's equally as valuable, perhaps, as a patent. Patent requires, as you've indicated, full disclosure in order to secure the monopoly. A trade secret, like the recipe for Coca-Cola, or, you know, things like that, as long as they're kept secret and not disclosed, are protectable forever. So yes, there are circumstances, and those are business questions, I think, more that have an impact on legal strategy. But there can be scenarios where you may choose not to disclose your invention by way of a patent, and rather seek to protect it in other ways. You know, the proviso, of course, is the notion of reverse engineering and the consequences that may arise once the product is in the public domain. But yes, there could be circumstances where you would consider using an alternative route.
Thank you, Georgina. Another question asks, is there a need for non-disclosure agreements to cover any IPR?
Okay. I'm a huge fan of non-disclosure agreements. Yes. The short answer is yes, there is a need for non-disclosure agreements. Particularly, but perhaps always, at the early stages of development, and when you are reaching out to others to you know, at the formative stages, I think non-disclosure agreements are critical. You know, some intellectual property rights actually can be lost if you disclose elements of those rights, you know, before you actually seek to register those rights. So yes, non-disclosure agreements are enforceable in Canada, and they are recommended in a variety of contexts. Yeah.
Well, we have someone else asking here, if my trademark is registered through the Madrid Protocol, should I amend it to cover Canada?
I don't want to get into the particulars of how to do things, but if your trademark was registered some time ago using the Madrid Protocol only, then prior to Canada acceding to the Madrid Protocol, it likely did not include Canada. So at this point, you want to give consideration to if you're doing business in Canada or looking to do business in Canada, to securing those rights in Canada, either by way of a domestic application. That's what I would suggest to you. But I'm not, you know, not giving, you know, legal advice. But yes, you should give some consideration to providing enhanced protection to Canada if that's the market you're doing business in. And if your Madrid application was filed some time ago, it likely did not include Canada. I hope I answered your question sufficiently.
Thank you. Another one asks, can you elaborate on the IPR border enforcement regarding GIs a little bit more?
Sure. So to participate, so this is a new thing and it's very exciting. And I actually don't have a sense of how many GIs are actually registered with Canada Customs, but the opportunity to do so is available to GI. So my recommendation is to give some thought to that process. The form to file a what we call a request for assistance, or the recordation of your rights with Customs, is available online, or you can reach me after and I'm happy to send you the link. If you file your request for protection with Canada Customs, then should a product come in that is marked with your geographical indicator that is not either produced in the country where that GI is provides protection, or in accordance with how it provides, in accordance with how the product has been developed or is used, then Canada Customs can identify that product as a potential infringement of your GI and contact the association or country that has the GI protection registered, and steps can be taken to preclude that product from entering Canada, or alternatively from being exported from Canada with a false marking. So it's a great opportunity, and it's relatively new, and it's still, in my estimation, an underused tool that is available to rights holders to add to their arsenal of brand protection rights available in Canada.
Thank you, Georgina, for that excellent and clear presentation. I have a question regarding delays in processing trademarks application for some of our members. In fact, it seems that examination requests can be considered within a minimum of 2 years, and the delay can exceed 3 years in specific cases. That long processing time sometimes creates difficulties for rights holders in enforcing their trademark rights in Canada. What are your thoughts on that? Is it a consequence of a potential lack of resources allocated to the processing of trademark applications?
That's a great question. That's a $64,000 question that trademark agents and trademark lawyers in Canada have been grappling with. Because of the extensive changes that Canada has undertaken in its basically a full overhaul of its trademark regime, things are delayed. That's the reality. And so there is a consistent lobbying effort, and I don't mean capital L lobbying effort, but lobbying effort to try to cut down those times and cut down, you know, basically work with CEPO and others, and they are doing their very best, of course, but those are just the realities of our processing time for trademark applications. We are confident that those times will be shortened as things get up and running and things will become more efficient. But for now, those are the challenges that applicants face in Canada. In terms of enforcement of rights, there are still common law rights that are available to, if you can establish goodwill and reputation in the market in Canada. There are still rights that are available to you as it relates to passing off, irrespective of the existence of the registration. But those rights depend on the realities of the facts and the use in Canada of your product and the goodwill of the trademark and the goodwill that you may or may not have established in Canada while you are awaiting registration. So all is not lost. There are opportunities for enforcement. It's simply that the enforcement opportunities that are available to you upon registration are delayed. But there are other avenues that are available if you can establish rights in your trademark at common law.
Thanks, Georgina. Another question here we have is relating to your last response on GIs. Would goods in transit through Canada be subject to IPR border enforcement?
Such a great question. Yes, now they are. They weren't up until July of this year. They were one of the express exemptions from the border enforcement regime. But when Canada signed on to the Canada, United States, Mexico trade agreement, that was one of Canada's obligations. In order to meet its obligation under that trade agreement, the old NAFTA agreement, Canada was required to include in-transit goods into its IPR border enforcement regime, and it has done so. So the answer is yes. And of course, that is a critical advantage now that rights holders have, because it was a huge problem in Canada that goods passing through Canada that customs may have identified as being counterfeit or infringing of GIs, they would sort of say, well, there's nothing we can do, and they had an informal memorandum of understanding with other customs agencies, but they couldn't actually act on the information. And now Canada Border Services is empowered to act on information when goods are in transit. So great question. New change in Canada came into effect, I believe, in July 2020.
So I don't see any more questions. I want to thank again Georgina for this wonderful presentation. Thank you to everyone. These are the social media pages of the European Union Delegation to Canada, which I invite you to follow. And all the best in your journey to Canada. Thank you very much for joining us today, and thank you, Georgina, for a wonderful presentation.
Thank you very much.